Hi, I'm Riley Morris. I'm with the Mississippi Center for Justice, and I'm one of the senior attorneys in the Biloxi office.
And I'm Robert Weigel. I'm an attorney in private practice here on the Mississippi Gulf Coast.
We're going to take a few minutes with you today to talk about general questions that come up when folks first decide they need to hire a lawyer but haven't had to do that before. And then also some questions about the particular problems that are facing folks who might have oil disaster related claims and are looking at the complex federal court litigation that's underway. So Robert, why don't you start by talking a little about questions that commonly come up when people need to choose a lawyer?
Certainly. One of the first questions that comes up is, how do I find a lawyer? And there are a lot of ways that people find attorneys. Perhaps you already know someone who handles family business for you. You can find one by calling your state bar association. And at the end of this videotape, maybe we could put up the state bar number.
Sure.
So that people can see that. You can also find one by asking your friends and family if they've had dealings with an attorney that they felt like was a good attorney.
So if you're going in to talk to a lawyer, and we've had a lot that have come through this area, what are some of the really basic upfront questions you want to be asking that lawyer right off the bat?
Well, particularly if you're talking about claims that are related to the BP oil spill, you want to know whether the attorney has experienced environmental claims. In other words, claims that have to do with damage to natural resources or people that have been harmed by oil spills or similar types of events. You want to know if the attorney has experience with complex cases, because there are a lot of cases related to the oil spill, and there are going to be a lot of complex legal, scientific, and other questions that are associated with that. You want to ask whether the attorney has experienced federal court litigation, because many of the oil spill cases will be brought in federal court.
And we're dealing with a situation where an individual in Mississippi is looking to make a contract for legal services in Mississippi with a lawyer. And anytime that happens, you want to make sure that this lawyer you're talking to is in fact licensed to practice in Mississippi, or that he has an attorney working with him who is licensed to practice. Another common question that you need to get cleared up before you go to hire a lawyer is, does this lawyer have an office here in Mississippi where you can go and see this person? And whether this person in this firm has legal malpractice insurance in case there's an error in handling your claim and you have to turn to the lawyer's insurer to make yourself whole.
Another aspect of that, Riley, is that if your primary language is a language other than English, or if you're most comfortable in Vietnamese, Spanish, or another, doubt how you're going to communicate with that lawyer effectively. Are you going to need a translator? How will that lawyer find a translator? Will you need to provide your own? And if the lawyer provides a translator, will you be charged for that translator's services?
So Robert, talk a minute for folks about the way that lawyers collect fees in cases like this, and whether there's anything special about this particular litigation that folks should think about at the front end when picking a lawyer.
That's a critical issue. Lawyers generally charge in one of two ways. They either charge an hourly rate, in which you pay them for each hour that they work, or they charge what is called a contingency fee. And the contingency fee is one in which they take a percentage of whatever is recovered for you as a fee. If you're in a position where you cannot afford to pay a lawyer an hourly rate, often a contingency fee is the option that you would have to get representation. Now, contingency fees can range anywhere from 10% to 40% of the recovery in a typical case. But the oil spill cases that we're seeing are not typical. Many of the contracts that we have been seeing with attorneys have contingency fees that range from 20 to 25% of the recovery. That is an aspect of the lawyer's fee that is subject to negotiation, and you need to be very specific and ask whatever attorney you decide to hire how much they will be charging you, what percentage of any recovery that would be, and make sure that that is spelled out in any contract that you sign. Now, there is another aspect of the oil spill that's unusual, and that is that British Petroleum has set up a claims process where people can go, and if they have lost earnings, lost wages, or lost business as a result of the oil spill, they can make a claim, and British Petroleum is at least paying something up front for many of those claims. Many attorneys are not charging a fee for the basic assistance in that claims process. So you should inquire with any attorney that you may hire about how they will charge you if British Petroleum voluntarily gives you money in that claims process.
Now, would it be true that for folks who do decide to bring a lawsuit and hire a lawyer, that the best practice is to get a written contract signed by you and the lawyer that spells out the agreement?
That's absolutely true. That's one of the most important things that you have to do. Anytime that you hire an attorney, you should have a written contract which spells out the terms of your agreement. That includes how much you will be charged, as well as what kind of expenses you will be responsible for if you ultimately recover. Those expenses can be things like court filing fees, copy costs, travel costs, and things of that nature, and you want to be sure that you understand what kind of expenses your attorneys will be ultimately passing through to you if you recover.
Now, we're looking at some folks who are facing losses here for whom English is not the native language. And we're also looking at some lawyers, not all lawyers, but a few lawyers who are putting some pressure tactics on people to sign a contract right away. Isn't it the best practice for folks to wait and fully understand the retainer agreement and not be required to sign the agreement on the spot?
It would be a very unusual situation, even in a situation like this oil spill, that you needed to sign a contract with an attorney immediately. As in most situations, if you're being pressured to sign a contract immediately, it may not be in your best interest to do that.
And just in general, how important for the attorney-client relationship is it for the client to have a comfort level, a feeling of mutual respect?
I think that is something that you should trust your instincts on. If you feel comfortable with your attorney and feel like they are listening to you and paying attention to you, that's a very important factor in the relationship. That raises another point, which I think is very important, and this is related to whether the attorney that you talk to is licensed in Mississippi or Louisiana or wherever you may be bringing your lawsuit. Find out how that attorney will communicate with you. Can you talk to the attorney directly? Will you be talking to a paralegal or a secretary in the attorney's office? Is the attorney's office convenient to you? Will it be easy for you to make appointments to go and speak with your attorney? Those are very important factors.
Okay, now in some cases, this will be the first time that a person will have to have had this interaction and have to think about hiring a lawyer. If a person meets with an attorney just at the very front end, does he have to hire him on the spot, or what are the ways in which that is commonly arranged?
Absolutely not. Not only are you under no obligation to hire an attorney simply because you meet with them, but if you do become dissatisfied with the representation that you're getting from an attorney, you can let that attorney go and hire someone else. Now, if you do that, the attorney